Good morning, everybody. Thank you all for joining us. We are almost all in from the waiting room. All right, I'm going to go ahead and get us started while we're waiting for the last couple of folks to make it in from the waiting room by covering our Zoom housekeeping items, which I do every week. And I'll start by asking everybody to stay muted during the Q&A unless you want to unmute yourself to ask a question, which you're welcome to do. Speaking of asking questions, the best way to ask a question, if you have one that comes up during the Q&A, is to pop it into the chat. The chat button or icon is on your bottom toolbar, and it might be flashing right now because I just put a message into it. That is also where you will find your audio and video buttons so that you can stay muted, but unmute to ask a question if you'd like to do that, or be on camera versus off camera, whatever your preference is, we're fine with that. And the message I put into the chat does also remind everybody that if you have questions in advance of an upcoming Q&A, please send them to info@condolaw.net no later than 4 p.m. on Monday afternoon. So we have a day to research our answers. And finally, that message also includes a link to our YouTube channel where you can find all of our, or most of our previous Q&A videos. And this is particularly helpful because I think there are at least 2 questions on our list today where we covered exactly the same topic in a recent Q&A. So we'll probably gloss over those answers today and refer you back to a previous video for you to get the in-depth answer to those questions. So please keep all of that in mind. Another thing that we cover every week is just reminding you that we are not here to give legal advice. We are here to answer general questions that we think are broadly applicable and helpful to community associations in Washington, but we can't give legal advice in this forum because we are not your association attorney. But even if we are your association attorney, this is not the appropriate forum to have attorney-client privileged conversations. And also, in order to give competent legal advice on just about any question, we would need to know probably a lot more specific details than we can cover in this forum. We'd need to understand, your governing statute, the contents of your governing documents, and that's just not something that we can do here. So if you find yourself submitting questions or wanting to ask questions that are really specific, if you're copying and pasting excerpts of your governing documents, if you are giving us, 3-paragraph description of something really annoying that your board is doing that you want us to tell you is a bad thing, we are probably going to decline to answer those questions because we cannot give legal advice here. So please do keep that in mind. We might have a little bit of extra time for questions today. So if you want to pop any additional questions into the chat as we get started, feel free to do that. There are 2 other announcements that we want to make everybody aware of. One is that the LAC fundraiser, that's the Legislative Action Committee fundraiser pickleball tournament, is coming up on May 16th. That's through the Washington State Community Associations Institute. And the link for that event is in the chat. That's on May 16th. Again, it's a fundraiser for the LAC, so please consider attending. You do not have to play pickleball in order to come and have fun at that event. So if you don't already have plans on May 16th, I know that's coming up in just a week and a half, consider a relatively low-cost ticket. I think it's like $30 to attend in support of the Legislative Action Committee. The other event that's coming up, and I don't have a link for this, so Chelsea, if you could grab one and stick it in the chat eventually, that would be great. The WSCAI Virtual Law Day event is coming up on June 9th, and I believe it is from 12 to 4 on June 9th. And we are going to be covering all kinds of legislative and legal topics, including our lobbyist will be there to do a legislative update on the session that just ended. And we'll talk about some of our legislative priorities for the next legislative session. And thank you, Chelsea, for putting that link in the chat. So that is on June 9th. Again, it is a virtual event, so it's really easy to attend from wherever you are. And we hope that you guys will consider coming to that as well. I think that's everything for announcements. Unless you have anything, Jennifer, I will jump us into the questions. All right, first one. If a unit owner passes without a will or a will that has not been recorded, can the association legally lay claim to the unit? We are presently under 6432 and 6434. The answer to this question is a categorical no. regardless of what statute you are governed by. There is no legal mechanism by which an association can just lay claim to a unit simply because a unit owner has passed away. The only way for an association to take title to a unit is, well, there's a few ways: through foreclosure of a valid lien, by accepting a deed in lieu from an owner, but of course that would require the owner's consent and signature, which would not be possible if they've passed away, or by actually purchasing a unit that is listed for sale. The only other method of taking possession of a unit is that if it is not owner occupied and there are at least $2,000 in unpaid assessments only, a foreclosure option followed by a receivership motion could be possible. So if you have a unit owner in your community that's passed away and there is a past due balance and you're trying to look at how to stop the bleeding and also maybe secure the unit, you need to consult with your association attorney about what you should do, what steps you should take, and what things are possible given the balance due, the composition of the balance due, and other things like that. I think that's all I need to say on that one. But if you have anything to add, Jennifer, you are welcome to do so.
I don't have anything to add.
Okay.
So the next question is, we are presently under 6432 and 6434 and have a question concerning executive sessions. We do not have account numbers for our condos, but we do have unit numbers which are reflected on a mounted map in the lobby. If a concern and decision on a unit is made in executive session, how do we then come to open session and make a motion concerning the unit without mentioning the unit number or name of the person? If the unit number is mentioned, it can be found by meeting attendees and expose the person to public exposure. So we covered this in detail on the Q&A a couple weeks ago. So we're just going to gloss over this, and then please feel free to go onto our YouTube channel and check that. So you can always refer to executive session agenda item 1 or some other way of identifying the issue being voted on without using unit numbers or other identifying information. But this does not work if you are voting on starting a foreclosure lawsuit. You must use the unit number or another unique identifier in the vote. And the citation for that is 6490-485. But you can also make up an account number and then going forward, use that account number for discussing items in executive session. You could also use like the last 4 digits of the parcel number for that particular unit. There are ways to create a unique identifier that are a little harder for people to find, but you also need to make sure that you are not entirely disclosing information. But also remember, you're not required to completely shield an owner's identity. Only take reasonable measures so that if the issue discussed or voted on could violate the owner's privacy, you're doing your best to give that privacy. So collections isn't specifically listed in 649455, which applies to everyone as of January 1st, 2026. Collections or delinquencies are not an item that is allowed to be discussed in executive session. It's not listed in this statute. So neither is potential violations of the governing documents. So the legislature did carve out an exception for items that could violate an owner's privacy, but did not specifically list delinquencies, collections, or potential violations of the governing documents. So if a board feels that those particular items are could violate an owner's privacy by discussing it in open session, you could take that into executive session. But remember as well, you cannot completely shield an owner's identity. You have to have a way of identifying it, especially if you're going for a foreclosure action. So just be reasonable, use your best guess, and if an owner has a complaint that somebody found out and confronted them, there's honestly nothing that the board could or should have done to prevent that. Valerie, did you have anything to add to that?
I just want to emphasize something that Jen said, which is executive session. There is a statute that lists the topics that are appropriate for executive session, and delinquencies are not on there. And I know that we still have lots of clients that still insist on only having delinquency related discussions in executive session. I'm not going to say that that's a statutory violation, but the votes do have to take place in the open session, and you have to be able to identify the specific unit or account in some way in the minutes when you are recording a foreclosure decision in order to comply with the statute. So make up your own list of account numbers that will forevermore be assigned to your units. Use the parcel number. Whatever system you use other than the unit number, pick something and stick with it. Or you can just use the unit number, but do understand that especially with specific types of votes like a foreclosure lawsuit, you do have to be able to identify the unit and the foreclosure vote in the minutes. And by unit, I don't mean specifically the number. I just mean somebody has to be able to look at those minutes and go, oh, that's the unit they were talking about when they voted on that foreclosure decision. It has to be easily identifiable to somebody who knows your community. Jen, you, I think, have the next one as well.
Oh, yes, I do. So, the question is, I asked the question in today's, meaning last week's Q&A about accrual accounting. Can you give me the specific statute in 6434 that Ken referred to in his answer, saying that it was required once a year? So for 6434 communities, the statute is 6434 372 sub 1, but it's also under 6490 530 sub 1. So all communities are required to use accrual accounting at least once a year to either do the audit if you're required to do an audit or to reconcile your books. Valerie, did you have anything to add to that?
I do not. I will go ahead and move us to the next question. A homeowner is months behind on assessments and was ignoring late notices. Now they're threatening bankruptcy and they say we won't collect a thing. What actions can a pre-WUCIOA HOA take to limit losses in this type of situation? All proper notifications per the RCWs have been sent. So, the bottom line is you need to contact your association attorney. But taking a step back as to some of the owner's comments, it's important to note that it is not impossible to collect assessments simply because someone files bankruptcy. There are multiple different types of bankruptcy. Some of them specifically contemplate the owner keeping their home and making a payment plan to repay the association for the unpaid assessments. Also, it's important to note that even if and when a unit owner does receive a discharge in bankruptcy, that discharge impacts their personal liability only for the pre-bankruptcy debt. It does not affect the association's lien against the property, and the association retains its right, if the composition of the balance due is correct and all the other statutory requirements are met, to foreclose that lien against the property, even once there has been a discharge of personal liability. So we can't speak to any particular account. I don't know how far behind this unit owner is. I don't know what your collection policy says. I don't know how much money is owed. I don't know what the assessment only balance due is, etc. But these are all the questions that I would be asking my client if they kind of, called or emailed me in a little bit of a panic over this situation. So people say all kinds of things. Also, I think it is important to note that people threaten to file bankruptcy all the time. And if I had to just ballpark guess out of all the hundreds of homeowners that have threatened bankruptcy in the years that I've been doing this work, maybe, I don't know, 20 or 30% of them actually do, because bankruptcy has specific qualifications that you have to meet as a debtor before you can qualify to file and then receive a discharge in bankruptcy. So the bottom line is, and by the way, this answer is true for all communities, whether you are under WUCIOA or not, regardless of your governing statute. If you have an owner who is delinquent, if they're more than, say, 3 months behind, if the balance due is more than, I don't know, $1,000, it's at least worth a quick call to your association attorney to say, here's the ledger, here's what they're saying, here's how long it's been since they've paid, what should we do? Also, if you don't have a collection policy that guides you when owners fall behind, then you should consider having your attorney draft a collection policy for you. We do this for our clients all the time. It's a relatively modest flat fee. And I imagine that's probably true for most of the other law firms in our practice area as well. And the great thing about a collection policy is that it does a number of things. One of those things is it educates your owners on what happens if they don't pay their assessments. But the other thing that it does is it gives the board and the management company a really clear roadmap for what to do when somebody falls behind, including what notices to send and when to refer an account to your association attorney. So, bottom line, if they're threatening to file bankruptcy, I wouldn't really worry about that until they actually do it. It doesn't necessarily mean that you won't be able to collect, but you need to consult with your association attorney. And I think that covers it. But Jen, if you want to add anything, feel free.
Just a quick plug that if you don't have an association attorney, especially one that specializes in association collections, it's a good idea to get one because statute states that the association can recoup attorney's fees and costs for delinquencies and collection, where that's not true for a collection agency. Also, association collections is a much different ball game than just regular collections.
Yeah.
So if you don't have an attorney specializing in community associations, it's a good idea to find one.
Yeah. And as I always say, you want to take your time and find an attorney like that when you don't need one desperately, because then you can take your time, you can interview multiple firms and pick the firm that feels like the best fit for your community versus scrambling and in a panic because you have to meet a deadline or something time sensitive is happening. All right, next question. The board treasurer and president have requested that we, the association management company, call and email owners directly regarding overdue payments or payments in collections. Our collections team advises against this and says it creates a he said, she said situation that can become a legal issue, but they did not provide a more detailed reasoning behind this. Are you willing to provide an explanation on the ramifications of contacting owners regarding their overdue accounts? I actually answered this question in an email last week as well. And I think it's perfectly fine for managers or board members to call or email unit owners about their past due balance, especially if what we're talking about is a short, simple courtesy call or email reminding them about the status of their account, right? I think a quick phone call or an email is fine. I am not talking about sort of like hounding people by calls or emails, like kind of how you see debt collectors doing in the movies or whatever. That's not what I'm talking about. But here's the reality. It's 2026 right now. And a lot of people ignore their snail mail. They just don't even open the paper mail that comes to them in their mailbox. And if you've been coming to this Q&A long enough, you have heard me tell this story before, which is that the number of times unit owners they'll say, I had no idea I was delinquent. And I'll say, well, your association sent like 7 notices before this came to my office. Didn't you receive those? And people will say, I don't know. I just don't check my mail. I don't even open my mail. So if the whole point here is that you're trying to avoid the cost of the collections process and you're trying to get the bill paid, a phone call or an email can make a huge difference. And I also want to say that despite the fact that the notice provisions in our statutes currently default to mail, I have a case right now where an owner has filed counterclaims against the association, one of which is that the association was unreasonable in failing to call or email the owner before escalating to the legal process when they had the owner's phone number and email address on record. So do I think that that's going to be a successful counterclaim in the long run? No. Am I still having to deal with that counterclaim on my client's behalf with insurance defense attorney involved and, discovery, and we're 2 years into litigation on this one? Yes. So I think calling and emailing people is fine. I think it's actually probably more effective than sending something in the mail. However, you do still have to send the notices that are required by statute and by your governing documents in the mail. This is not a substitution for that. It's not a substitute for sending notices in the mail. It's just an addition to that. As far as the he said, she said thing, I think the way that you deal with that is that you just send a follow-up email or letter confirming the details of the conversation. So if you call somebody up and you have a 3-minute conversation with them and you remind them that their balance due is, past due, and that they have, they have portal access or whatever, um, hang up the phone and send a short email after that, just saying, I just wanted to confirm the details of our phone call today. Thank you for taking my time to talk with me. I reminded you that your account is past due, and you shared that you would try to log in sometime in the next week and make a payment. Like, boom. Then it eliminates the he said, she said, because you've got a written record. With email, it's much less of an issue because you've got the communication in writing. It's less subject to interpretation. And I do want to say also, one of the concerns that I hear a lot from managers in the industry is, but what about the FDCPA? What about, we don't want to violate the FDCPA? In the Ninth Circuit, management companies are not considered debt collectors. The Ninth Circuit is our circuit of the federal court system, which decides whether certain federal statutes apply to certain people, right? There are other circuits in the United States that have held that in that circuit, a management company is a debt collector and they are subject to the FDCPA, but the Ninth Circuit is not one of them. So a manager making a phone call to a homeowner to follow up on a past due account is going to be treated until something changes in the Ninth Circuit anyways, it's going to be treated just like if a board member were to make that phone call. So it's not the same as if you're hiring a third party debt collector like a collections agency or even like a law firm like us to collect on the association's behalf. One other caveat or just pointer is that the person who is making the call or sending the email should make sure they are double checking so they are completely sure of what the balance due is before they call or email the owner. In particular, if you're putting the balance due in writing, a written statement of the balance due may be binding on the association, even if it is not accurate. So you just want to make sure that you've got the numbers correct before you call or email them. I think that's everything on this one. And Jen, if you have anything to add, please feel free.
Nope, I don't have anything. So the next question is, how does a developer CC&Rs or declaration capture and translate the RCWs and county codes within the declaration, and must the board meeting and comply with all of these standards with the understanding that the declaration supplements these laws and codes? So how this procedure works is that the developer hires an attorney to draft the declaration, but the attorney uses a template that they have on file and then just plug in the relevant information for that particular association. So the information that the attorney is given may or may not be accurate as to how the development was built or is contemplated on being completed. So the statute that the association was formed under depends on when the declaration was recorded and what kind of community it is. So before July 1st, 1990, and if you're a condominium, that's 6432, the old act. From January 1st, 1990 to June 30th, 2018, for a condominium is 6434. For all HOAs, no matter when the declaration was recorded until June 30th, 2018, it's 6438. So all communities where the declaration was recorded July 1st, 2028 and after, it's 6490. And then some provisions of 6490 apply to all communities now. So, as regard to county codes, we're not sure what you mean regarding this. We don't know of any county codes that relate to governance, meetings, but there may be many codes that relate to zoning, land use, density, or conservation, etc. A good set of CC&Rs or declaration would refer to any county required restrictions for development. Often those relate to native growth protection areas, wetlands, stormwater retention, etc. So the association would be expected to follow county codes applicable to the property, the same as any other property owner. The declarant and the declarant's attorney use a standard set of CC&Rs for the community that hopefully comply with current statute. We have run into situations where a community that is a new act condo was formed under a declaration for an old act condo, and it can create some confusion. If you have questions on your declaration or what the developer did or how things were done, please contact your association attorney. Valerie, did you have anything to add to that?
No, I think you covered it. Our next one is pretty straightforward. Is there a Northwest MLS resale certificate form to support RCW 6490-640? And how can I get it? The short answer is that we are not aware of an MLS form. And since the resale certificate is supposed to be provided by the association, not by one of the listing real estate agents, for example, not or the buyer for that matter. I'm not sure how easy it would be for an association to get it anyways. What we often tell our clients when they ask us a question about like this is there a form? Is there a form? Is there a form? Our clients don't really like our answer, but the statute is basically a checklist. If you print out that subsection of the statute that says everything that you're supposed to include in the resale certificate and literally check off the items as you compile them into the packet, whether it's a physical packet or a digital one, that's all that you need. You don't need a form to fill out. That being said, we have had some self-managed clients pay us to draft them a template resale certificate form that they can then use every time they prepare a resale certificate going forward. And I think that that's as effective as any form from a third party. I also have reservations about whether I'd want my clients using a form provided by the MLS, for example, as opposed to a form provided by an association attorney who's intimately familiar with these statutes versus, somebody that's an expert in real estate, but not necessarily an expert in community association law. So again, the statute specifically lists the information that must be provided. And I think the most straightforward way to do this is to just follow the statute. If you are a self-managed community and you're a little confused about whether what you are putting together complies with the statute, have your association attorney review it for you and tell you. Jen, did you have anything you wanted to add?
No, I think you covered it.
Okay.
So the next question is, we are an HOA governed under 6438. Is there any advantage into opting into UCIWA prior to January 1st, 2028 in terms of amending our governing documents? I have read that there's a lower threshold for member approval if we opt in prior to 2028. So I was wondering how this lower approval threshold works. Would this lower threshold apply only to changes required by UCIWA, or would it also apply to any changes incorporated that are not specifically required by UCIWA? So we've covered this in prior Q&As. I'm not sure what search terms would be useful because we talk about UCIWA all the time. But you can check our prior YouTube videos and find more information. So the advantage to adopting UCIWA early is that you will be familiar and used to complying with the statute before it becomes effective. So under 6490-370, and is an amendment just to an amendment just to adopt 6490 as the governing statute requires only 30% participation and at least 67 of the participants' approval. So you can adopt UCIWA with 30% participation as long as you get 67% of the participants to agree. If you have a higher number of participants than 30%, that's fine, as long as you still get the 67% approval. Any other changes would require the same approval as in the declaration. So if your declaration requires 67% approval for any amendments, that particular approval is still required. If your CC&Rs had a lower threshold for amendments, so some old act condos only require 60%, that 60% would only apply until January 1st of 28. After that date, UCIWA states all amendments require 67% approval. So brass tacks here, no association is required to amend or restate your governing documents to comply with UCIWA before January 1st of 28. The owners and board just need to be aware of where the statute overrides your declaration and where the declaration is allowed to be different than the statute. And we understand this can be really confusing for people. So if you want to not have that confusion of having to go between your documents and statute and try and figure this out, go ahead and amend or restate. It's just there's no requirement under the statute to amend or restate. You just need to know where the statute differs and where you're allowed to differ. Valerie, did you have anything? Oh, oops, sorry, this was a two-parter. So the second part, also, since amending our governing documents will entail a total restatement of our declaration, how do we present the amendments to our members for voting purposes? Do we need to delineate each change and have the members vote on each change, or can we provide our members with a draft of the amended document and have them vote to accept or reject the draft in its entirety without detailing each change? So when we're drafting a restatement, the procedure that we typically use is to have the owners vote on the document that will be recorded. The statute requires that owners receive a copy of the amendment and it's an amendment and restatement, not just a restatement, but they're required to see a copy of what will be the final document. So it's possible to carve out separate votes for particular topics that may or may not be a reason for someone to reject the document, such as a rental cap or some other potential action that is voluntary for the association, but the board thinks is a good idea. You should follow a process that you expect your community would understand and support. So, as I said, it's not a requirement to amend or restate to come into compliance with UCIWA. It's something you can do, especially if your documents are older and you want to take advantage of some of the provisions under UCIWA that allow for deductible shifting or damage shifting, but that's discretionary if it's in your governing documents. Valerie, did you have anything to add to that?
The only thing I'll add is about the process of having the restatement adopted by the community. And I just want to highlight what a recent client did, which was, and this was for a specific amendment, not for a restatement, but the same process applies to either. They had owners that were really confused about the contents of the amendment because it was very specific, it was an insurance amendment, so lots of kind of technical details. And also part of it was the ability to shift the uninsured costs to the unit where the damage originated. And that gave people pause because it was a potential for large dollar amount liability on the unit owner's behalf. The association board had us attend 2 or 3 different Q&A sessions, one in person, one virtual. They allowed their owners to submit questions that they then asked us to answer in writing so that they could address all of their unit owner concerns. And we think that a process that is as transparent as possible with the ownership about what the reason for the restatement is, as well as a process that gives them many opportunities to have their questions answered, is more likely to result in you getting the votes that you need to adopt the restatement. And then the only other thing that I will remind everybody about is that with a restatement or an amendment as well, when you have the initial meeting where you're talking about the draft of the restatement and you're trying to get the owners to submit their ballots in support of the document, if you don't get the necessary percentage that you need, the board does have the authority to extend voting on that amendment or restatement for any reasonable time not to exceed 11 months past the original deadline. So a lot of our clients, I think, worry because they wonder, like, we don't even get a quorum at our meetings. How are we going to get 60% or 67% or whatever of the ownership to vote at a meeting on this restatement? And the reality is the voting process takes longer, and there are lots of different ways to encourage different groups of people to vote over a period of time rather than feeling like you have to get all the votes at that one meeting. So looks like there's a follow-up question about a previous topic in the chat. You encouraged calling owners who are behind in their assessments. What about calling owners who are in violation of rules and regulations, either in advance of or after a notice has been sent? I think communication with your ownership is always a great, I mean, almost always, I guess, but I don't want to be like too black and white here, but it's almost always a great idea. And I also think, here's the thing, you guys are community associations, and the word community means that you are living in community with other people. And whatever approach that you choose to take to communication with your ownership, whether it is about violations or delinquencies or upcoming special assessments or a project that has to be done within the community, the method that encourages folks to communicate with you and that is sort of starts with the least confrontational method possible is always what we recommend. So if your board wants to, at the same time that you would normally send a warning notice for somebody who is violating the governing documents, make a quick courtesy call to somebody and say, hey, we noticed that your garbage cans have been left out too long, or that your lawn hasn't been mowed in 27 weeks, or whatever the violation is. We're sending you a warning notice, but we also wanted to give you a courtesy call so that you're aware that this is coming. And, if you have questions for us or whatever, I think that kind of communication is rarely a bad idea, especially if you are still following your fine and enforcement policy by sending the required notices, whether it's a warning notice or an actual violation notice. And of course, also making sure that the due process language in the letter before every fine is assessed is appropriate. You just have to make sure that you tell people before you fine them that you're going to fine them and that they have the right to request a hearing before the fine is assessed. We can give sample language if somebody wants to email us about that, but that's the most important thing, is that you have to follow it up with the written notices that are required under the statute. Follow-up question, does the full board have to determine there is a violation first? Jennifer, do you want to take that one or you want me to take it?
I can take it.
Okay.
So, statute requires and gives the board the authority to determine whether or not something is a violation of the governing documents. So, the board can delegate that authority to a committee, but when a committee is exercising board authority, they are subject to the same standards as board meetings under 6490-455. So, a majority of the board at present at a meeting can determine whether or not something's a violation, or a majority of a committee that has at least 2 board members and only the board members vote can determine whether or not something is a violation. But other than that, you can't, the board, you can also delegate that authority to the management company if you want. But the problem becomes it's ultimately the board's authority. So the board needs to exercise its own authority or pass that authority on to a committee or the management company. And but yeah, it cannot be just one person or a couple people on the board unless it's a full committee that is following the same standards as a board for meetings. Valerie, did you want to add anything?
Yeah, I would say too, if you are as a board going to delegate your authority to make violation related decisions, you should clearly document sort of the 4 corners of what is being delegated, who it's being delegated to, where does that authority start, begin and end. Because one thing you cannot delegate as a board is your duty of care to the association. And how that comes into play when you're talking about violations is, if it's a really easy, straightforward kind of open and shut situation where there's a photograph of the violation and it's a clear violation of the rules, the board's duty of care to investigate that type of violation, the bar is lower there, right? But if it's a noise complaint, if it is a owner complaining about a neighbor harassing them, if there is any sort of nuance or ambiguity in the situation, Then the board's duty of care comes into play, which includes a duty to investigate whether a violation has occurred. And I think they can delegate actions, but they cannot delegate their duty of care. That's not something that can be delegated to somebody else. So what I would say is if a board is considering delegating stuff like this, they should consult with the association attorney to work with them on a really clear description of what they're delegating, who they're delegating it to, and when certain things have to come back to the full board for a decision. And thank you, Jennifer, for answering that question in the chat about the RCWs for the fine process and due process that's required. I'm going to go ahead and jump us to the next question so we can get through these, and then we'll continue to come back to the chat if there are additional questions once we're done with our pre-submitted ones. If a lien is only valid for 3 years, and in 2028 under WUCIOA, it changes to 6 years, does that change the effect of the earlier lien? We are currently governed by the older condominium statutes. So I want to clarify some terminology here first. There is a statute of limitations on collecting unpaid assessments. Currently, if you are a condo association not subject to WUCIOA, you have a 3-year statute of limitations. If you are under the HOA Act, courts have interpreted the statute of limitations there as being 6 years. It's essentially the contract's statute of limitations. And WUCIOA, the statute of limitations is 6 years. This does not affect the validity of a lien necessarily, but what it does affect is your ability to collect older amounts due if they are barred by the statute of limitations. So the question about if you're a condo association that currently has a 3-year statute of limitations, does WUCIOA for all taking effect on January 1, 2028 magically convert you to a 6-year statute of limitations? I wish that it was that straightforward. WUCIOA very clearly states that the statute of limitations is 6 years. You will be subject to WUCIOA, but you also presumably have a declaration that currently says the statute of limitations is 3 years. And if your governing documents say the statute of limitations is 3 years, the conflict with the statute that will then exist at least creates an argument that the more specific term of the contract, the declaration, controls over the statute. But here's the good news. Well, I mean, I don't know, people just like to ignore this advice sometimes, but it should never be left so long that this becomes an issue. Even if you have the shortest statute of limitations that we're talking about here, which is 3 years, you should never wait that long before taking action to collect on unpaid assessments. Or at a minimum, you should never wait that long before you consult with your association attorney about what steps you should take. The only thing that stops the statute of limitations from making older amounts due uncollectible is filing a lawsuit. Recording a lien doesn't stop the statute of limitations. Sending delinquency notices doesn't stop the statute of limitations. Entering into a payment plan does not stop the statute of limitations. The only thing that stops it is filing a lawsuit, unless there's a written payment plan agreement where the owner waives the statute of limitations, but that's a very specific situation. But one of the things that we know from handling probably thousands now of delinquencies over the course of the last, I mean, I've been doing this for 17 plus years, is that the older a delinquency is and the higher the balance due by the time it gets to the law firm, the harder it is to collect in full and the more expensive it is to collect in full, and the more likely it is that we will have to file a lawsuit in order to collect. Conversely, if you get us a delinquency when the owner is only 3, 4, 5, 6 months past due and it's a relatively low balance due, I get the sort of like hesitation to do that as a board, right? Because there's legal costs involved in referring it to your attorney. And it probably feels hard to look at a balance due of $2,000 and then send it to the attorney where you know that it's going to add $1,000 just right out the gate, right? You're adding 50% to the debt just by sending it to the attorney. But the lower the balance due is when we get involved, the more likely the owner is going to be able to pay that off via a payment plan versus if it's 5, 6, 8, 10, 15, 30,000. I mean, you would not be, it's shocking to me sometimes the size of these debts when they come to us. If it gets that big, most people are just completely unable to wrap their brains around a way to actually catch up on that. And so the response to us getting involved and recording a lien and sending a demand letter and trying to work out a payment plan is basically the bigger the debt is, the more likely the owner is to ignore everything, except for maybe the prospect of losing their home in a sheriff's sale, in a foreclosure. So going back to the original question, when WUCIOA for All takes effect in 2028, if your governing documents specifically state a 3-year statute of limitations, I think it's an open question as to whether a court would interpret that the way we think it would, which is the more specific term controls, the term that is more favorable to the unit owner controls as a matter of public policy. And the statute is unlikely to trump the written statute of limitations in your specific documents. This and maybe one more argument in favor of restating if that is a project your community is considering. But the flip side of this is don't wait so long that this becomes an issue, even at the 3-year mark. And if you haven't already established a collection policy and a clear timeline for referring things to the legal process for a lien and a demand letter, then you should consider working with an association attorney to get that process and timeline in place so you can be as proactive as possible, because that will increase the odds of collection in full. It will decrease the odds of litigation and high legal fee costs, and will eventually be beneficial to your community in the longer run. Jen, did you have anything to add?
No.
Okay.
So the next question is really lengthy, so I'm just going to summarize. This particular individual was using AI and questioning it in different ways about 6490-515, requiring that any notice under WUCIOA be provided in the form of a record, and limits electronic notice to owners who have affirmatively consented. So, and they go on to state, at the same time, 6490-455 distinguishes between unit owner meetings and board meetings, which with much more specific notice requirements for owner meetings. So the AI was trying to answer this question, and the individual goes on to state, in other words, is there a defensible distinction where lack of electronic consent defaults to mailing for unit owner meetings, but not necessarily for board meetings? So the short answer is no. 6490-515 provides that any notice required to be delivered to the owners is provided as a record, sent either via first-class mail, personally delivered, and this is personal service, not just handing it to someone or posting it on a door, or delivered electronically if the owner has opted into receiving electronic notice. So any notice required to be delivered to the owners must be provided in a record and sent as provided in 6490-515. There's no distinction between unit owner meetings and association meetings for notice. Notice is notice is notice. That's just it. Valerie, did you have anything to add to that?
As you might imagine, I do. So I want to clarify one thing that Jen said, which is the notice section of the statute controls how you can give effective notice under the statute. And that is the sort of the highlight here, right? If it's a notice that has to be given to an owner, then you have to do it in compliance with the notice section, period, end of story, full stop. And it doesn't matter whether the notice is for an association meeting or a board meeting. But my bigger comment here is about AI. And I fully understand that AI is here to stay. I understand that there are probably many applications of AI that are reasonable to use and maybe more reliable. But in the legal realm, AI is notoriously defective and makes mistakes all the time. And part of how I know this is that one of our paralegals, about once a quarter, I would say, runs the text of WUCIOA through AI and then asks a series of simple questions, and it nearly always gets these simple questions wrong. Another reason that I know this is that, you know, when you Google something and then there's like the AI summary before there's the actual search results in response to your Google inquiry, about a third of the time that AI summary is completely wrong. It's getting better. It used to be half the time. I think it's down to maybe a quarter or a third of the time now. So it's getting better, but it is still a very, very, very imperfect tool. And one of the things that actually Chelsea said when we were doing our prep meeting ahead of time is one of the features of AI is if you keep asking it a different question, if you keep asking it a question a different way, it eventually is going to give you the answer that you want. And that is the difference between AI and an attorney, or at least an ethical attorney. We have clients that will very specifically tell us what they want us to say when they ask us a certain question. And there are times when we can support the outcome that they're asking us for. And there are other times when we just cannot support that outcome because it is counter to either very clear statutory language, case law, or governing document language. So I just would really, really, really caution you all against the use of AI in the legal realm. And oh, one other thing that you all should be aware of is that across the country, there are dozens of cases over the last couple of years sanctioning attorneys for the use of AI in preparing pleadings that they file in cases on behalf of their clients. Because AI literally makes stuff up. It will literally create a case that does not exist, tell you that there's a case out there named XYZ that stands for this proposition, but that case does not exist. And attorneys have been, you know, copying and pasting stuff straight out of AI and not actually cite checking those cases to make sure that they actually exist. And sometimes they're getting found out in the courtroom in front of the judge, where the judge will be, yeah, like, I looked up this case, it does not exist. Do you think I'm missing something, counsel? Anyways, the point is, if AI is fooling attorneys who are trained to do what we do, it is definitely going to fool lay people. And one other thing that I'll mention is that more and more we are dealing with clients using AI in the way that they communicate with our office. So we'll get a question or a series of questions from a client that is very clearly a chat GPT. Like, it is really easy to spot AI, like copy and paste stuff. And one of the things that we're seeing, in addition to the fact that AI gets things wrong, is that it asks a lot of unnecessary questions that we have to take the time to answer, and then we're billing our clients for that time. So not only is AI inaccurate some of the time, just enough, it's inaccurate enough that you just can't rely on it. It also is increasing, in some cases, the cost of attorney's fees when clients use it in communicating with our office. So this is my rant. I will now step down off my soapbox. And going back to the original question, I don't think we need to recap it. I copied and pasted the stuff in the statute about how you give notice and the fact that that is true no matter what type of notice or meeting that you're giving notice of. But I really, really, really do want to caution people against using AI, and especially against using AI to substitute consulting with your association attorney and or to try to get a different answer than you have heard here from your association attorney at WSCAI events. If you ask it enough and you ask it enough twisted, weird, convoluted questions, it'll give you the answer that you want, but it'll still be wrong.
And just a couple
Sorry,
of,
go ahead.
yeah, just a couple of quick things. I literally had a client send me a letter drafted by an attorney who was an owner who used AI and had a citation that did not exist. They didn't double check it. So owners are using it, even owners who are attorneys are using it and getting it wrong. We also had the paralegal take the statutory language about delinquencies and the pre-foreclosure notice of delinquency and run it through AI to draft a delinquency letter. It got it wrong. So AI is a good tool for grammar, for trying to figure out how to word something. But
It's great for party planning. I use it to plan parties sometimes, or like playlists for certain themed part because I like to throw parties. Menus, if you want to put in a bunch of ingredients and tell it to give you a recipe that use these ingredients you have in your kit. I mean, there are so many simpler, like less high stakes functions that you can use AI for, but legal stuff should not be one of them.
and my husband is an IT professional and says that you treat AI like you would a very, very, very junior employee and double check everything that it says.
Yeah. Okay, I'm going to move us to our next question. In making a motion to approve a project proposal or quote, what is the essential information to include? Should the cost and funding source be included in the motion and therefore in the minutes? Is there anything that should be excluded? Most of the time, I think it can be just as simple as I move to approve the bid from XYZ vendor for ABC project. Because presumably the bid has all of the specific information and you don't need to regurgitate that in your motion and in your minutes. Approved bids or proposals are considered association records, so you can look at RCW 6490 495 subsection 1I. That's a mouthful. To look at the record section and the retention of those types of records. I would advise against using account numbers or any other personally identifiable information in the meeting minutes or at all. Your funding source is going to be included in your financials. I think dollar values probably make sense to include. I don't think they're necessary or required, but I think it doesn't hurt. And it does ensure that the board members understand fully what it is that they're voting on. And it also wouldn't hurt to specify if this is a reserve expense or an operating expense in the motion. But again, I don't know that I think that's necessary. There's no statute that says that has to be in there. So I think as long as the motion and then the minutes make it clear what you are proposing the board to vote on, who the bid or the estimate is from, what the project is, what the estimated cost to the association is, I think that that's fine. And do keep in mind, your minutes are not intended to be a verbatim like transcript of the meeting. They're intended to essentially record at a high level the actions taken by the board at that meeting, bullet points and sort of basic information to identify the decision being made is all that's necessary. Jen, did you have anything you wanted to add?
No, I don't. And we can probably cover this last one really quick.
Okay.
So the question is, in relation to rewriting the declaration, it was mentioned in the past that an association could eliminate some statements of the declarant since declarant control is no longer applicable. How extensive could the elimination of declarant roles or references be achieved? So, depending on the age of the association, most references to the declarant can be deleted. So, the general rule is that once the declarant is gone, virtually all of their roles can be changed. But there still may be governmental restrictions on the land or other private restrictions. If there is still development rights existing, and we've just done a restatement for a client that has a tract that is still under declarant control, you can't delete everything. So talk with your association attorney about drafting the restatement and what you want and don't want. But also remember that a declaration is a very technical document and should be done by an attorney specializing in community associations. This is not something that a board or a committee can do on their own, even if the committee is made up has an attorney who does not practice in this practice area. It costs more and takes us more time to fix something that a community has drafted rather than us doing it under a flat fee and having it done correctly the first time. Valerie, did you have anything to add to that?
I don't. And that takes us right up to 10:59. I don't think we're going to have time for any additional questions. So thank you all for joining us. We're happy that you were here with us this week. We'll see you next week. And if you have questions before then, send them to info@condolaw.net. Thanks, everybody. Bye.